Fine, the jury's coming in. Welcome back, ladies and gentlemen. I'm sure over the course of the last week plus, at times you must think, geez, Borowski cannot tell time, because I said you'd be around 9 and it's more like 10. We've been discussing a few things, discussing the jury instructions. I'm going to read you the jury instructions. The jury instructions are frankly rather lengthy. They're somewhat, if not complicated, at least involved. So I don't expect you to memorize them. You don't have your notepads. You don't need your notepads. There's no way you can memorize them. Rain Man couldn't memorize them, okay? So you will get a copy of the instructions when you deliberate after the instructions and the closing arguments. Ladies and gentlemen, members of the jury, as I've said, I will now instruct you on the principles of law which you are obligated to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law that I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and judgment, reach your verdict. If any member of the jury, if any of you has an impression of my opinion as to whether the defendant is guilty or not guilty, you are to disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the judges of the facts. The court is the judge of the law only. Evidence. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, any exhibits the court received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I have directed you to find. Anything you may have seen or heard outside of court is not evidence. You are to decide this case solely and only on the evidence offered and received during the trial. As you know, in this case, the information charges first-degree intentional homicide, use of a dangerous weapon. It's alleged that on or about September 22nd of 2020 at 1750 North Holton Street in Milwaukee, Milwaukee County, the defendant did cause the death of Jason Cleereman, another human being, with the intent to kill that person, contrary to the Wisconsin statutes. To this charge, the defendant has pled not guilty, which means the state must prove every element of the charged offense beyond a reasonable doubt. Crimes to consider. First-degree intentional homicide, self-defense, second-degree intentional homicide, first-degree reckless homicide, and second-degree reckless homicide. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide or first-degree reckless homicide or second-degree reckless homicide or, finally, homicide by negligent use of a weapon, all of which are less serious degrees of criminal homicide. Intentional and reckless homicide. The crimes referred to as first and second degree intentional homicide and first and second degree reckless homicide and homicide by negligent use of a dangerous weapon are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by the law depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant cause the death of the victim. First and second degree intentional homicide require that the state prove the additional fact that the defendant acted with the intent to kill. First and second degree reckless homicide require that the defendant acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Homicide by negligent handling of a dangerous weapon requires that the defendant cause the death of the victim by criminally negligent conduct in the operation or handling of a dangerous weapon. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense. The criminal code in Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use force. Let me back up. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. Provocation. You should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he or she is in imminent death, imminent danger of death or great bodily harm, he or she may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he or she reasonably believes that he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. A person who provokes an attack may regain the right to use or threaten force if the person in good faith withdraws from the fight and gives adequate notice of the withdrawal to his assailant. A person who provokes an attack, whether by lawful or unlawful conduct, with the intent to use such an attack as an excuse to cause death or great bodily harm to another person, is not entitled to use or threaten force in self-defense. Retreat. In determining whether the defendant reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had the opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. As applied to this case, the effect of the law of self-defense is as follows. The defendant is not guilty of any homicide offense if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent an imminent death or great bodily harm to himself. Continuing, the defendant is guilty of second-degree intentional homicide if the defendant caused the death of Jason Cleereman with the intent to kill and actually believed the force was necessary to prevent imminent death or great bodily harm, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if the defendant caused the death of Jason Cleereman with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of Jason Cleereman by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. The defendant is guilty of second-degree reckless homicide if the defendant caused the death of Jason Cleereman by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first- and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty of first or second degree intentional homicide or for first or second degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed gentlemen. I just discussed something with the attorneys, obviously, just to clarify it. Let me reread that last sentence and then continue. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first or second degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will then be instructed to consider the last offense of negligent homicide. The facts necessary to constitute each crime will now be defined for you, explained in greater detail. First-degree intentional homicide, as defined in the criminal code, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. The burden of proof. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Jason Cleereman. Cause means the defendant's act was a substantial factor in producing the death. 2, the defendant acted with the intent to kill Jason Cleereman. And 3, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the action. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from the facts and circumstances, in this case, bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While a motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, the defendant did not actually believe he was in imminent danger of death or great bodily harm, or 2, that the defendant did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be considered only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman with the intent to kill, and the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant or must not find the defendant guilty of first-degree intentional homicide. And you must then consider whether the defendant is guilty of second-degree intentional homicide as defined in the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on that charge, on the charge of first-degree intentional homicide, you then should and must consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Jason Cleereman. 2, the defendant acted with the intent to kill Jason Cleereman. And 3, the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in the circumstances of the defendant would not have believed he was preventing or terminating an unlawful interference with his person. Or 2, that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm. Or 3, that a reasonable person in the circumstances of the defendant would not have believed that the amount of force necessary, strike that, amount of force used was necessary to prevent imminent death or great bodily harm to himself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts or actions, and not from the viewpoint of you, the jury, now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. Your decision, if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of second-degree intentional homicide. And you then must consider whether the defendant is guilty of first-degree reckless homicide as defined in the Wisconsin Criminal Code. This homicide is also a lesser included offense of first-degree intentional homicide. You should and must make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in a unanimous agreement on the charge of second-degree intentional homicide, you should and must then consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Jason Cleereman. Cause means the defendant's act was a substantial factor in producing the death. 2, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death of great bodily harm was unreasonable and substantial. The defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all evidence in this case that the risk was unreasonable. And 3, the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. Again, the burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. The jury's decision, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminally reckless conduct and the circumstances showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree reckless homicide, and you should and must then consider whether the defendant is guilty of second-degree reckless homicide in violation of the Criminal Code of Wisconsin. Second-degree reckless homicide is a lesser included offense of first-degree reckless homicide. Again, you should and must make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of first-degree reckless homicide, you should then consider whether the defendant is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in the Wisconsin Criminal Code, is committed by a person who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide. The difference between those two homicides is that first-degree reckless homicide offense requires the proof of one additional element. That is, that the circumstances of the defendant's conduct showed utter disregard for human life. If you're satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring the circumstances of the conduct showing utter disregard for human life, you should find the defendant guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminally reckless conduct, you should find the defendant guilty of second-degree reckless homicide. If you're not so satisfied, you must not find the defendant guilty of second-degree reckless homicide. You then should and must consider whether the defendant is guilty of homicide by negligent handling of a dangerous weapon in violation of the Wisconsin Criminal Code. That offense is a lesser included offense of first and second-degree reckless homicide. Just as with the other offenses, you should and must make every reasonable effort to agree unanimously on the charge of second-degree reckless homicide before considering the offense of homicide by negligent handling of a dangerous weapon. However, if after a full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of second-degree reckless homicide, you should and must consider whether the defendant is guilty of homicide by the negligent handling of a dangerous weapon. Homicide by negligent handling of a dangerous weapon is committed by one who causes the death of another human being by the negligent operation or handling of a dangerous weapon. The burden of proof. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant operated or handled a dangerous weapon. 2, the defendant operated or handled a dangerous weapon in a manner constituting criminal negligence. 3, the defendant's operation or handling of a dangerous weapon in a manner constituting criminal negligence caused the death of Jason Cleereman. Cause, again, means the defendant's act was a substantial factor in producing the death. Dangerous weapon. Dangerous weapon means a firearm, whether loaded or unloaded. A firearm is a weapon that acts with the force of gunpowder. Criminal negligence. Criminal negligence means a defendant's operation or handling of a dangerous weapon created a risk of death or great bodily harm, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant should have been aware that his operation or handling of a dangerous weapon created the unreasonable and substantial risk of death or great bodily harm. The difference between criminal recklessness and criminal negligence. Criminal recklessness and criminal negligence both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal recklessness requires that the person engaging in that conduct be aware of that risk, while criminal negligence requires that the person engaging in the conduct should have been aware of that risk. The jury's decision: if you're satisfied beyond a reasonable doubt that the defendant caused the death of Jason Cleereman by criminal negligence in the operation or handling of a dangerous weapon, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. You are not, and these are all important, but this is important, you are not in any event to find the defendant guilty of more than one of those offenses. Use or possession of a dangerous weapon. The information, the charges in this case, allege not only that the defendant committed the crime of either first or second degree intentional or first or second degree reckless homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty of any of those foregoing offenses, you must answer the following question. Did the defendant commit the crime of first or second degree intentional or first or second degree reckless homicide while using a dangerous weapon? Dangerous weapon means a firearm, whether loaded or unloaded. Before you may answer the second question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer that question, no. I told you guys these were long. What?
Burden of proof.
In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless during your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of proof. The burden of establishing every fact necessary to constitute guilt is on the state. Before you can return a guilty verdict, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. Reasonable doubt. Reasonable doubt means a doubt based on reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt based on guesswork or speculation. A doubt which arises merely from sympathy or from the fear of returning a guilty verdict is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of making a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. Information, the information which I read from earlier is nothing more than a written, formal accusation against the defendant, charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Improper questions. You are to disregard entirely any question that I, as the court, did not allow to be answered. You are not to guess at what a witness's answer may have been. If a question itself suggested certain information might be true, ignore the suggestion and do not consider that as evidence. Objections. The lawyers for both sides have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing testimony or other evidence to be received over an objection of an attorney, I, as the court, am not indicating any opinion about the evidence. You, the jury, you jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Expert opinion. Ordinarily, a witness may testify only about facts. However, a witness with expertise in a particular field may give an opinion in that field. You should consider the qualifications and credibility of any expert, the facts upon which any opinion is based, and the reasons for any opinion. Opinion evidence was received in this case to help you reach a conclusion. However, you are not bound by any expert's opinion. Circumstantial evidence. It is not necessary that every fact be proven directly by a witness or an exhibit. A fact can be proven indirectly by circumstantial evidence. Circumstantial evidence is evidence from which you, the jury, may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you, the jury, to decide. Exhibits. An exhibit becomes evidence only when it's received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Police reports. During the course of the trial, the lawyers may have referred to or used police reports with witnesses. In most cases, these reports will not be provided to you. If you are not provided a police report, you need to use your collective memory regarding any reference to such report. The weight of the evidence. The weight of the evidence does not depend on the number of witnesses on either side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. The jury's knowledge. In weighing the evidence, you, as the jury, may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Credibility. It is your duty, the duty of the jury, to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. If you believe that any of the parties or the court has an opinion as to the credibility of a certain witness, disregard and do not consider that, as you are the sole judges of the credibility of the witnesses. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the trial, the witness's conduct, appearance, and demeanor on the stand, the clearness or lack of clearness of a witness's recollection, the opportunity the witness had for observing and knowing matters testified about, the reasonableness of a witness's testimony, the apparent intelligence of a witness, any bias or prejudice, if any possible motives to falsify testimony, and all other facts and circumstances during the trial which tend to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. As you know, the defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. You should use the same factors to determine the credibility and the weight of the defendant's testimony that you would use to evaluate the testimony of any other witness. There's not a magic way for you to evaluate testimony. Instead, you need to use your common sense and experience. In everyday life, you determine for yourselves the reliability of things that people say to you, and you should do the same thing here. Any remarks or comments by the attorneys are not evidence. If a remark or a comment suggested certain facts not in evidence, you're to disregard that suggestion. Evidence was received in this case that the defendant had other open cases at the time the charged offense was committed. That evidence was allowed only as it pertains to the defendant's credibility and should not be used for any other purpose. Furthermore, evidence was received that the defendant was temporarily restricted from possessing a firearm at the time of the charged offense. While one may be temporarily restricted from possessing a firearm due to court orders, this shall have no bearing on whether the defendant was privileged to act in self-defense. Under the law, the defendant still had the right to act in self-defense at the time of the offense, and you are to decide only whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense. Finally, evidence was also received that the defendant was on bail at the time of the charged offense. This fact shall also have no effect on your deliberations as to his guilt or innocence as to the charged offense. You are to decide this case solely and only based on the law and facts presented to you during the trial. In just a minute, both sides will make closing arguments. You are to consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. You are to draw your own conclusions from the evidence and decide upon and reach your verdict according to the evidence and under the instructions given to you by the court. At this time, I'm going to ask both sides to make closing statements. I have told both sides that they have a maximum of an hour and a half total each, an hour and a half each for closing arguments. I've encouraged both sides to recognize that they don't need to use that entire hour and a half, and they may be shorter, but they will certainly be no longer than an hour and a half. That's a hard stop from this court for both sides. We'll proceed, certainly start and proceed with the closing from the state. Mr. Huebner.